SJC-12291, Andrew Segal v. Genitrix, LLC, and others.
Good morning, Mr. Dupree, and welcome to Massachusetts.
Thank you, Mr. Chief Justice. Tom Dupree on behalf of the defendants, appellants Johnson and Rose. And may it please the court. The Wage Act confines liability to a narrow set of specific individuals. In this case, the judgment below imposed liability on the basis that defendants were agents having the management of the company, even though it is undisputed that defendants were not agents of the company, at least in the sense that the common law has historically defined agency, and even though defendants, an investor, and a board member did not have management authority over this company. If left standing, the decision below sends a chilling message to investors, banks, consultants, entrepreneurs, anyone contemplating doing business in the Commonwealth. I'd like to begin with the agency point. The plain text of the Wage Act identifies 4 types of individuals who could be held personally liable: the company's president, its treasurer, its officers or agents who have the management. In this case, it's undisputed that the defendants were not the company's president, they were not the company's treasurer, and they were not officers of the company. Therefore, for the judgment below to be sustained, the plaintiff needed to prove that the defendants were agents. Now, as we set forth in our brief, it is our view, and I think the only permissible, reasonable reading of the statute, that when the legislature included the word agents in the Wage Act, it adopted the common law definition. The Wage Act does not define agents, and it's this court's practice, as well as the guidance issued from the legislature itself.
What about our interpretation of the Wage Act, where we've looked at functional equivalency and not the common law definition of agency? Isn't that what we should be looking at, is whether or not your clients had the functional equivalency of managers?
Well, 2 points on that, Your Honor. The first is that the functional equivalency standard was not the theory that this case was tried, nor did it go to the jury. In fact, the district or the Superior Court expressly refused to instruct on functional equivalency. But putting that aside, I think at the end of the day, Your Honor, the functional equivalency test gets to the same sorts of things that the agency inquiry would turn on, namely that to be the functional equivalent of the president, the defendants would, number one, need the power to bind the corporation, as every corporate president can. Here, undisputed, they lack the power to bind the corporation. Second, a company president exercises day-to-day operational management of the company. Here, the record is undisputed. In fact, the plaintiff himself testified that he was the one who exercised day-to-day operational management of the company. So both because the case was not tried on the theory, the jury was not instructed on the functional equivalence theory, the evidence doesn't support it.
The instruction was a person qualifies as an agent if he controls, directs, and participates to a substantial degree in formulating and determining policy of the corporation, right?
That was the instruction.
That was the instruction. So the jury had the ability to weigh this evidence and decided against your client.
No, well, with respect, Your Honor, I think the problem with that instruction that Your Honor read is that it skips over the definition of agent. It doesn't require the plaintiff to prove agency. What that instruction does, Your Honor, is it restates the test that this court has articulated for when the having the management prong is satisfied. It's a circular definition. The Superior Court essentially said anyone who exercises management authority is an agent having the management. The effect of that instruction, Your Honor, was to erase the word agent from the statute. The jury was not instructed to make a finding of agency. The verdict slip did not ask the jury to make a finding of agency. To be sure, the Superior Court did address the management point, which is the point that Your Honor read, but it failed to instruct on agency, and because this is a JNOV case, it's our view that because the plaintiff failed to prove agency, his claim fails as a matter of law.
Do you think that the judge instructed, as it relates to agency, consistent with Cook and Weidman, or not?
It is not, Your Honor. It is not, Your Honor. Both Weidman and Cook addressed the second prong of the test, that is to say, the having the management portion of the test. And that's what the Superior Court was focused on. Our argument here is that in issuing that instruction, and the reason why it is not consistent with Weidman, Cook, or the text of the statute for that matter, is that it skipped over agency. There was no requirement that the jury find that these defendants were agents of the company. That's critical. All the jury was asked to do was to make an evaluation as to whether they exercised management. We think that finding was wrong as a matter of law, but the first argument we have is that there was simply no finding of agency. That's a critical requirement in the statute. In fact, in the Bisson case, which was authored by the Superior Court several years ago, that court correctly analyzed the statute as having two requirements. The first requirement is you have to be one of those four people mentioned in the statute. You got to be the president, treasurer, officer, or agent. Once that's satisfied, then you can make the management inquiry, at least as far as officers or agents are concerned. And the problem in this case is that the Superior Court failed to give any meaning to the concept of agent.
But I thought Bisson goes one couple of steps further. Doesn't it say that you can be the functional equivalent of the president, the treasurer? Right. It doesn't just limit you to those positions, right?
That's true. I think what the Bisson court was concerned about was the notion that someone who really was the company president could give himself a title other than president and thereby try to circumvent liability.
So are you suggesting we adopt the Bisson standard here? Is that your view of what agent means in the statute?
We think what agent means in the statute is the common law definition. And by that, I mean the definition set forth in the restatement. It's been recognized by this court, which is, was that individual...
That's what Bisson does, doesn't it?
I think so. So to the extent that's what Bisson... I just want to make sure I'm correctly answering Your Honor's question.
Right.
To the extent that's what Bisson holds, yes. Our position is that the proper definition of agency is the common law standard. That would require a showing that the ostensible agents were specifically delegated the authority to bind the company. That's the restatement, historic common law definition going back more than a century of agency. That's what we want. That's what the jury was not instructed on. But again, more to the point, it's a failure of proof. It's a JNOV issue. They needed to prove agency. They failed to prove agency. Therefore, we're entitled to judgment.
Yeah, we don't have many cases. In fact, is this the only case we've ever had in which the plaintiff could have sued himself for failing to pay himself his wages?
Your Honor, that is one of the many ironies and peculiarities of this case. That's exactly right. The plaintiff himself was the president of the company, so he is one of the few people who actually would be personally liable. But I think Your Honor's question illustrates a larger point, is that Dr. Segal is obviously not the type of person the legislature intended to protect when it passed the Wage Act. Dr. Segal was the president of the company. By his own testimony, he managed the company's day-to-day operations. He authorized the paychecks. He had the power to bind the company. So the whole point about functional equivalency, I think, is a little misplaced in that there's no dispute that Dr. Segal not only was the nominal president, he was the actual president in terms of the functions by his own testimony that he performed. What the plaintiff tried to argue in this...
Excuse me, isn't there evidence that, given the kinds of funding that were available to the company at a later stage, that had he tried to pay himself, he would have been there for probably 20 minutes?
Well, Justice Lank, I don't think that that argument from the plaintiff supports either a finding of agency on behalf of the defendants or a finding that the defendants had the management. What the defendants in this case did, and this was his purported evidence of management, is that through Fisk Ventures, which is a separate LLC, Fisk Ventures made targeted investments in the company. But I think it's black-letter corporate law that a person or an entity, simply by being an investor in a company, doesn't somehow become an agent of the company or become the management of that company, even in cases like this one where there are conditions attached. I think it's fair to say that every commercial lender in the United States places restrictions on loans that they give to companies. I think it would be unusual or unique for a lender simply to say, here's $5 million, do with it what you will. Quite the contrary. When lenders give money, they typically will attach conditions. They say, this is money to build a new addition or to reinstate your patent rights or for some specified purpose. That's how the venture capital world works. And I submit that if the standard, by giving a loan to a startup company and saying this is the purpose for which we're making this investment, you automatically assume personal liability for the wages of all the company's employees, that can't possibly be something that the legislature ever wanted or contemplated. And it's certainly not what's in the statute.
So it's really a jury instruction problem. I understand you have a missing witness argument and an authentication argument, but put those aside. If there was a jury instruction that included the functional equivalent test, and there was a special verdict form coming back that this is the functional equivalent of the president or treasurer, you wouldn't have a problem despite the whole agency issue.
Well, I think we still would request a finding of agency, Your Honor, at least in the sense, well, because to be a functional equivalent, I think you have to have agents. In other words, an agent has the power to bind the company, and to be the functional equivalent of the president, you would need the power to bind the company. But I think the larger point here is that when Your Honor said this is a jury instruction problem, the jury instructions were faulty, no question about that. But the point I want to underscore to this court is that the remedy here, and our motion, why we're here before this court, is because we believe we are entitled to JNOV because the plaintiff needed to prove agency and failed to have evidence of agency. The plaintiff also failed to have evidence of functional equivalency, so it would fail for that reason as well, regardless of which lens you looked through it. But I just want to underscore that our contention here is that we are entitled to judgment as a matter of law, not simply a new trial, although the jury instructions were faulty.
But if the evidence in the light most favorable to the plaintiff was that there was a functional equivalent of a president or treasurer, then agent having management really isn't applicable. I don't understand your comment that to have functional equivalency, you have to have agency.
Well, to be the functional equivalent of the president of a company, you would have to have the power to bind the company. I think that's common ground. I mean, it seems self-evident that the president has the authority to act on behalf of the company and to bind the company through his actions. It's undisputed in this case that the defendants did not have the authority to bind the company, full stop. Therefore, they can't have been the functional equivalent of the presidency. Another point, another functional equivalent of the president is who was the person who controlled the day-to-day operations of the company. That's what a president does. In this case, the record is undisputed. Dr. Segal himself testified that he was the one who managed the day-to-day operations of the company. That's a separate, independent reason why, even viewed through a functional equivalency lens, we could not have been the functional equivalent of the president. We didn't have the power to bind the company, and we didn't manage the company's day-to-day operations, the two critical aspects of being a company president.
Let me ask you about these targeted investments. Take, for example, the payments to Dr. Young, the wage payments to Dr. Young. Am I to understand that Rose, acting through the investor LLC, would say we need to make this payment to keep our intellectual property viable, correct? So one thing was they would pay certain employees, they would pay patent rights and legal fees, correct?
Well, that's not quite right, Your Honor.
Okay.
It was the plaintiff who said, hey, we need to pay this person, and approached Fisk Ventures, the independent LLC, and said, we think it's important for the company to pay Dr. Young.
So we have payments of selected people, we have payments to keep the patent going, correct?
Well, when you say payments of selected people, I think the important point here, Your Honor, is that it's not my clients who are making the decision to accept the investments.
Okay, but on the targeted, there are certain categories of targeted investments.
For the category of target investments, it's not my clients who are making the decision to accept the investments and the conditions to that. That's the
All right,
company, and that's Dr.
I'm trying to
Segal.
get you to tell me the procedure. So Segal says we need money for a certain reason.
Yes.
They go to Fisk. Fisk says, okay. Then it has to go to the board,
Yes.
and Segal has veto power.
Yes.
And then after the board accepts the money, Fisk pays.
Yes, and Fisk, well, I guess one clarification. Segal has to approve it as the president, but yes. So, yes, I think Your Honor correctly sketched it out, and I think that the critical point here is that at the end of the day, it is the company itself, not my clients, who have the power to decide whether to accept the investments. My clients couldn't force the company to do anything. They didn't have the authority to make these decisions on behalf of the company. This is requests for investment that come from the company and that are approved by the company. Those are the critical legal elements here.
And it's initiated by Segal
Yes.
in
Yes.
every instance of targeted investment.
You know, I certainly in most of them, I don't want to say every single instance because there were a number of investments, but in every instance, they were approved by the company and signed off by Mr. Segal. And of course, as Your Honor correctly noted, to get approved by the company, since Mr. Segal and his appointees had veto power on the board, it was all done with their approval. Since my white light is on, if I can make one last point.
We'll give you that point, but Segal, he had equity in the company?
Yes, Your Honor.
How much?
Well, he was a Class A investor, and so originally the board split was 50-50. Then over time it increased, or my client's, the so-called Johnson block increased to 60%, but for purposes of board approval, it required 75% board approval. So as a practical matter.
So the venture capitalists swallow up some share of the equity, which is the norm in a struggling
That's right.
startup, but he still has equity.
Absolutely, Your Honor.
So the success of the company then financially, potentially, could have benefited Segal.
That's exactly right, Your Honor.
I guess the question is, how many somewhat rhetorical, but it's pretty routine for startups to have people defer receiving compensation in the hope that they can get past a difficult time with equity. What does this open up?
Well, Your Honor, I guess 2 points. One is this is an extremely common structure, notwithstanding the somewhat somber, ominous narrative that Segal paints in his brief. The facts of this case are extremely common. This was a startup, venture capital, small biotech startup that failed, and then the president sues his investors. That is the structure of this company, as we had testimony from a Harvard Business School professor, Professor Gompers, explained that this is an extremely common setup for LLCs in Massachusetts and throughout the country. Now, as far as Your Honor's question about consequences go, this is the point I wanted to leave the court with, is that if the plaintiff's view of the world prevails, here's what the world looks like. No one in their right mind would want to invest in a Massachusetts startup or serve on a corporate board in Massachusetts, because if that company fails to make payroll, that person could be personally liable for all of the wages of all of the company's employees, treble damages, and potential criminal indictment, as the Wage Act carries criminal penalties as well. That cannot possibly be what the legislature contemplated, and it certainly is not what the legislature wrote into the Wage Act itself. For that reason, we ask the judgment below be reversed.
Okay, now, I promised you the last opportunity. Had I unwittingly opened the door to that?
Well, it naturally flowed, Your Honor, from your question. Thank you.
Hey, thank you. Mr. Wilton, good morning.
Good morning, Your Honor. May it please the court. First thing I want to say is that Rose and Johnson, we don't argue that they were liable under the Wage Act because they were members of the board or did things that board members do, nor because they were investors and did things that investors do. We argue that Johnson and Rose, really Rose was the lead, and he was Johnson's agent, that Rose essentially took over the management, the day-to-day management, and that's what we proved at trial to a jury, and that's what the jury found. Specifically, there was an email that they sent to Dr. Segal about 2 or 3 years before the final end-up of the company saying that they would not move forward with this company if Dr. Segal, quote, controlled the management of the company. They were saying they were going to take over that management. Thereafter, day-to-day decisions had to be made by Stephen Rose. And indeed, you will see that the evidence was, and both testimonial evidence and documentary evidence, that Stephen Rose, that Dr. Segal would say, for example, I want to sell the lab equipment that we have in storage to free up funds to pay me and the other expenses. Rose, apparently without consulting anybody else, just says no. They do this over and over again. Rose says no. Dr. Segal says we think we need to lay off Eli Young, Dr. Young, because we're running out of money. We can't pay him anymore. Rose, and apparently, again, there's no evidence that Rose went out. It's certainly not a board meeting or anything like that. Rose simply says no. Now, Rose has 2 other board members in his pocket, so to speak, so he has the power to do that. He also has Johnson, his principal.
Meaning they have to hire an interim CEO to do what they're doing, and if they do it directly, they're violating the Wage Act? I mean, because they have to do something, right? The company's got no money, they're board members, it's their money. They can't get their hands into the company to try to save their investment. They have to hire a formal agent to do that. I mean, I'm just trying to understand how this is going to work in the real world.
Yes, I understand, Your Honor. And first, Mr. Rose was the board member at that point in time. Mr. Johnson had removed himself. So there were 5 board members. But the actions that Rose took were not taken as a board member. Rose simply directed Dr. Segal whether he could sell things, when he could terminate Dr. Young, under what
But
circumstances.
if they
and
passed
so
board
forth.
votes, they could do this legitimately then, right? So
Pardon me, Your Honor?
If they acted if they had a board meeting and told him to do every single thing they told him to do, that would be fine and not a violation of the Wage Act?
I think, Your Honor, that if policy were made by a board, I think it's a fine line, and honestly, I think it's a fact-intensive inquiry, but policy being made by a board does not make a board member liable under the Wage Act. But day-to-day operational control does. And that's a jury question, I believe. I believe it's a jury question as submitted to the jury under the Waidman standard that says, did they control, direct, and participate in the management of the business?
So if the targeted investments, as Mr. Dupuy laid out, went before the board with Segal having veto power, you don't have a problem with that. That's not management.
It is management for Rose to run the show, no matter how he does it, Your Honor. And to the extent they make board...
Even if Segal says, I need money to pay Dr. Young's salary, and give us that money, it goes in front of the board, and Segal, with veto power, approves it, you're saying that Rose is still the manager?
I'm saying, Your Honor, that Rose made the decision about what was going to happen. Dr. Segal didn't want to pay Dr. Young. Dr. Segal wanted to terminate Dr. Young. Rose said no. And then Rose said, and I'll give you the money to keep him on for a while. And they said, and that then had to be circulated. And by the way, I'm not sure all the board resolutions ended up getting circulated to everybody, but it was circulated, I think, enough to everyone that they approved it. But these board resolutions are not such as, we're going to put in X amount for payroll. These were X amount to pay Dr. Young's salary, X amount to, and with regard to Dr. Young, they were not go. I don't think this one ever went to the board, that they told Dr. Segal that he couldn't put the non-compete clause. Rose told him I couldn't put a non-compete clause in the termination agreement. These are all things that Rose personally did. Now, I think what's important here, a couple of things about agency. Right? The first is that when the legislature uses the word agent, even the restatement recognizes that when legislatures say agent, they don't necessarily mean a common law technical agent. It says specifically, some statutes in many cases use agency terminology when the underlying relationship falls outside the common law definition. It's been recognized, this particularly has been recognized by the appeals court in Commonwealth versus Cleary, where the court in that case said that agent as used in General Laws Chapter 271, Section 39A, quote, they say the legislature is using the word agent in the broader sense, and it does not require a responsible, quote, agent, unquote, to possess authority to bind his principal or employer to formal relationships with third parties. Agent doesn't always mean technical agent when the legislature uses.
But doesn't an agent in this context mean a person who has the power to pay these persons and did not exercise that power?
I think that agent in this case, Your Honor, first off, I don't think one word in that statute should be taken out of context, the
Okay,
word
well,
agent.
I'm referring only to the statute. So let's go back to the statute, which
Yes.
was passed perhaps before venture capital was even a term used. Wasn't the legislative intent to say anybody who has the power to pay those employees and did not exercise that power is liable?
Essentially, I believe that is about right, Your Honor. Yes, there's president, treasurer, and any agents or officers or agents with the management of the corporation. I think when what the legislature was trying to describe there, I think they're giving you a list of the kinds of people, examples of the kinds of people it intends to hold. And if you add that to there's two other sentences in there that are critical too, the one before and the one after. The one after describes public employee sector and who's responsible for payment for wages there, and they talk about fault. And the most important one, perhaps, is the sentence before, which is the sentence that says specifically, no person shall by a special contract with an employee or by any other means exempt himself from this section. And I think what they're talking about there, what they're saying there is that this act is intended to be, you're not allowed, if you're a responsible person in that list, you're not allowed to use legal tricks and hide behind corporate formalities to escape liability.
But they don't use the words investors or directors or, board members.
That's right.
They're avoiding that, right?
That's right.
And you're collapsing that distinction unless it's very fact-specific, that Rose was sort of way beyond what a director does, right?
Rose was way beyond what a director does, Your Honor. We proved that at trial through extensive evidence, and that's what the jury found. The jury found that Rose controlled, directed, and essentially managed Genitrix during those last several years.
Without a functional equivalent jury instruction.
Your Honor, I believe that the functional equivalent of the president is someone who controls and directs and manages the corporation, and that description that was set out by this court in Weidman 12 years ago, I guess it was now, I think that description is an appropriate one for this trial judge to use. I understand that the functional equivalency test was articulated by Justice Gantz. It's a wonderful test, but nevertheless, it was a Superior Court opinion, and my Superior Court judge thought he would go with the language from this court rather than that language. But I think that those mean the same thing. The jury is finding that Rose controlled the policies of the business.
Did he control the wages?
Pardon me, Your
Did
Honor?
he control paying the employee wages?
He did. Yes, he controlled paying all the employees' wages by saying, here's money to pay this guy, you're not paying yourself. Here's money to pay these other people. They paid, I think there was 3 other people that they paid.
But boards do control policies. That's what they do. That's what board of directors do. So, there's got to be something more specific we're targeting here, because boards set policy, they pick the CEO, they fire the CEO, they stop paying the CEO, right? That's what boards do. So this has got to be different from the ordinary situation, right?
Where it's done, I think, Your Honor, again, it's a question of how it looks to a jury in a sense. Where it's done, where they have a board meeting, they discuss and vote it on a policy basis, I agree. Where it is one person who in an email says, here's what's going to happen, I'll circulate it for everyone else to sign, that's not the same thing. And that's what we have here.
And was that, I haven't read that piece of paper you're talking about, or that email. Was that in the context of we're going to put more money into the company if this happens, or just a normal general direction about payment of employees?
There were several, Your Honor, numerous emails about all of these things. They were
So
different.
the key email is at what? Do you know where the record references to that? I just want to make sure I read that.
I think that, Your Honor, it's not just emails. The email I specifically spoke of was one in which Rose told Dr. Segal that they would not move forward participate in Genitrix if Dr. Segal controlled the management of the company. That's the email. Beyond that, there are numerous emails back and forth, as well as testimonial evidence concerning essentially questions about selling lab equipment.
You have the record cite to that handy, just,
I do not
Okay.
in front of me, Your Honor. I will make a
we
note.
we can find it, thank you.
If you're correct, and these individuals are indeed agents of the corporation, could they not be held criminally liable?
Your Honor, I think this, in a sense, goes to this rule of lenity argument that's been
Yes,
essentially rejected with
yes, it
regards to
does.
this. But nevertheless, I think, and the court talks about this, the idea that the rule of lenity doesn't necessarily apply to a civil proceeding that also has criminal potential as well. And the reason is, I think that it's common for criminal standards to be different from civil standards, and for a statute to be read differently in a civil context from a criminal context. And I think to the extent that I think, honestly, Your Honor, that this court has said, and I think this court is right, that the Wage Act is intended to be read as a practical matter, and it is intended to hold responsible those individuals with the power to shape the management, to shape the employment decisions of the company.
So do I understand you to be saying that it is possible for someone to be civilly liable but not to be criminally liable? Because the rule of lenity would apply.
Particularly, burden of proof makes that happen all the time, but I think there are other cases where that's true. I do not have them at my command.
All right, now let's address your brother's concern. This is a state which is full of venture capitalists trying to salvage failing startups, of whom a fair number of them have not been paying their employees because they don't have the cash on hand to do so. What does this mean if you win?
It means that, well, if a company is running out of money, it has to lay off its employees. That's what the Wage Act says. You can't work for free in Massachusetts. It's just a rule.
But you know that we have many officers, presidents who are essentially saying, I will defer getting paid because I've got equity in the company and I can't afford to pay me. I haven't been paid in 6 months, but we need cash to keep this afloat, and if I have any chance of realizing my hope to become the next Facebook, I need fresh cash, and I'm going to defer taking it myself in order to have that possible. We have a lot of those.
There are ways to structure compensation, Your Honor, I think, such that immediate cash would not be necessary, but we have to be careful because the Wage Act specifically forbids a company from contracting with its employee to postpone or lend it its salary. And so I think that with regard to executive employees, one could take a very small salary, but then there would be nothing. You would not have an accrued salary sometime to be paid in the future. You could take a zero salary. Or perhaps you could be given stock options as an alternative or something like that. But you cannot, that's a fundamental rule, that you cannot work for free in this state. No one can agree to do that.
Now, even if you're the president?
Yes, Your Honor, if you're an employee. If you are, I suppose a president could not be an employee. That's not the situation here. We had an employment contract, and he was an employee. The company had the ability, Johnson had the ability to fire him and didn't. They kept him working, and they paid everything else along the way for their benefit, but they didn't pay him.
So they should have fired him?
Pardon me?
They should have fired him, and then they wouldn't have had the
I think
liability?
that would have been a legal thing to do, but they wouldn't do that because they needed him to keep the place going so that they could end up with the intellectual property at the end. They didn't fire him for their own selfish reasons.
Counsel, do you think that it's at this point with the way startups are and the tech industry and the biology industry in Massachusetts that we actually need the legislature to take some action on this statute?
I think the statute stands as it is just fine, Your Honor. I think startups can work around the concern that an employee has to be paid for his work. I think, as I just said, you could take a small salary, or they could get stock options or some sort of thing that does not require immediate cash outlay if they are out of money. Otherwise, when the business is out of money, it has to close, just like most businesses do. You can't keep people working when there's no money to run the business.
Can I ask you a question just to clarify it for my purposes? In every wage decision made, you say, by Rose, did they all go through the board of directors, and were they all approved by the board of directors?
That I'm not 100% sure of, Your Honor. Many were, but I don't think all were, but I'm not. I can't say that with any degree of certainty. The truth is, Your Honor, that most of the board approvals were done sort of like later. It was mailed around. People signed different documents, mailed them in, and they got stuck in a file.
Right, but in every instance, Segal had veto power.
In every instance, Dr. Segal could have said, no, we're going to close the business, period, instead of trying to keep it going.
No, in every instance, he could have said no to the request for funding.
Yes, and that would have meant closing the business, Your Honor.
And could he also have paid himself? Back to Justice Lank's question, could he have paid himself?
There was no money to do so, Your Honor.
Well, but could he have, written himself a check and then gotten fired? Would that have been fine? We wouldn't be here?
I'm not sure. You're suggesting...
Well, I mean, he is the president. He is the person who signs his own paychecks, right?
Yes.
There's something odd about this, that he either cannot get paid and sue under the Wage Act, or pay himself and get fired.
In Dr. Segal's contemplation, he was eventually going to be reimbursed for the foregone salary when the business was liquidated. That did not happen, however.
Okay, thank you.
Thank you, Your Honor.